Cyril Chukwurah, 59938. Mr. Harris and Ms. Hamilton.
Good morning, board members. Wayne Paris on behalf of Cyril Chukwurah. Normally I don't talk too much about the background of the facts here, but I'm going to have to digress a little bit and give you a little bit of the background. Eric Hernandez was an illegal alien who was arrested and placed in custody in Houston for possession of a little less than 30 grams of controlled substance. Mr. Hernandez's mother went to see Mr. Chukwurah, who practiced immigration law at the time, and expressed to him that she wanted him to represent Mr. Chukwurah. She engaged him to represent Mr. Hernandez, Eric, her son. There was a discussion between Mr. Chukwurah and Eric Hernandez's mother. They discussed possible remedies as to how Mr. Chukwurah could help Mr. Hernandez. One of which item that was discussed and opined about was the possibility that since Eric Hernandez had been living with a common law lady in a common law relationship, that perhaps they could get a certificate of marriage from a justice of the peace, and as a consequence validate his living in the United States so he wouldn't be deported. Another thing that was discussed in this conversation with the mother of Eric Hernandez was the fact that perhaps we could get some sort of rehabilitative sentence over at the state court and a deferred adjudication. Another thing that was discussed was the idea that possibly they could get a bond through the immigration court and get Mr. Hernandez out of jail, which was his immediate concern. And another thing that was discussed was possibly Mr. Hernandez might be able to be eligible for the military in order to circumvent a later deportation. All these things were discussed in the attorney-client relationship. The bond application was filed with the immigration judge. It was denied. There was a motion for reconsideration filed with the immigration judge by Mr. Chukwurah for Mr. Hernandez. That was set for a hearing. At the hearing, Mr. Chukwurah was discharged as Mr. Hernandez's lawyer. A lawyer for the Immigration Service, Donald Cassidy, heard that Mr. Chukwurah had come to this bond hearing and had read in a previous section of the Bar Journal that Mr. Chukwurah had been under a probated suspension. So he filed a complaint he filed a grievance, if you will, with the Houston Regional Office of the Chief Disciplinary Counsel and said, we've got a guy that appeared over here that got discharged by his client right in front of the judge before the motion for reconsideration could be heard, and I want to know if he still is available to practice law, because I read somewhere where he was suspended or had a probated suspension. That led to a letter from the normal letter from the Chief Disciplinary Counsel's office asking Mr. Chukwurah to respond to a complaint, this as a complaint, although I don't know that inquiry should have been classified as a complaint, but nevertheless, Mr. Chukwurah responded with a whole set of facts involving what I've just told you about and how he was representing Eric Hernandez. Then Mr. Cassidy, a lawyer for the Immigration Service, comes back and in a rebuttal says, well, you know, all these remedies that he suggested to his client, he's all wet about them. They just don't exist under the immigration code and the immigration laws of the United States. And the Chief Disciplinary Counsel's office used that to form that rebuttal to form a just cause letter charging violations of 101, 201, and 8.04A3. Later on, of course, after an evidentiary petition was filed, they, in fact, added 3.01. Here's the interesting factor. we all know anybody can file a complaint with the regional counsel's office. We also know that that person doesn't have to be a client, and in this case, no client filed a complaint. But we also know that when that person files any kind of a form or consisting of a grievance complaint, there's a form where you waive the attorney-client privilege. No client in this case, neither Mr. Hernandez or Mr. Hernandez's mother filed a complaint. Donald Cassidy is the one that filed the complaint. He was a government attorney initially. He couldn't waive the attorney-client privilege between Mr. Chukwurah and Mr. Chukwurah's mother and Mr. Chukwurah's and Eric Hernandez. So the reason I say that there's no, and this is a no evidence appeal, the reason I say there's no competent evidence in the record is that all of the sanctions and all of the findings of the disciplinary rule violations here are based upon an alleged discussion between Mr. Chukwurah and his clients, of which nobody ever waived the attorney-client privilege. Obviously, you could say, well, Mr. Chukwurah appeared at the evidentiary panel hearing and testified. Fine, he can't waive the attorney-client privilege for his client, and neither client appeared at that evidentiary panel hearing and testified. Now, that complaint was raised up front by his then attorney. I didn't try the case in the evidentiary panel. I came in at the time of the motion for new trial, but that complaint was raised up front, was overruled by the panel chair, and the evidentiary panel proceeded. The reason I have said that there's no competent evidence in the record is because all of these violations are based upon those alleged discussions whereby he was allegedly, or his mother was allegedly given advice, all of which are attorney-client privilege. So I don't think that there's any competent evidence that can support this position. And you'll find that on page 9 of the brief where I've referred to the lack of the attorney-client privilege for that rebuttal letter that gives rise, if you will, to the fruit of all this poisonous tree and all the way down the line through the hearing. Aside and apart from that problematic area, let me talk about the alleged violations of the disciplinary rules that were found. What the Chief Disciplinary Counsel, the Commission for Office and the Commission for Lawyer Discipline put on is evidence.
Mr. Parris, can I ask you one question? I don't mean to interrupt your argument, but I just want to make sure I understand what you're telling us. I understand that only the client can waive the privilege.
Yes, sir.
But if Mr. Chukwurah, on his own, for whatever reason, decides to talk about it, isn't that a matter between he and his client?
You know, if he talks about it under compulsion of having had his lawyer up front object first, and then that objection is overruled, which is in the record, that is in the transcript. I mean, up front they said he doesn't want to talk about this because it's attorney-client privilege. That was overruled, and he finds himself then in an evidentiary panel situation where either he has to respond to the prosecutor's introduction of evidence, or he stands mute and is not in a defensive posture. That would be perhaps if that hadn't happened.
Let me rephrase my question. Assume that there had been no objection by the lawyer and Mr. Chukwurah just went ahead and testified. Would you be making this argument then?
I would still be making the same argument, but not quite as strongly. I still don't think the lawyer can waive it for two clients that don't even show up, that are never put on at the hearing, and that have never advised him to waive it. I think it's the client's privilege.
Well, I don't think anybody would doubt that. The only question I'm asking is if the lawyer just decides to talk, and we all do that, unfortunately.
Is that an implicit waiver?
I don't think it's a waiver at all, but it just seems to me that's a matter between the client and Mr. Chukwurah. It doesn't necessarily prevent it from being evidence here. That's what I'm asking you.
I think it does prevent it. I think anything that grows out of that, I've used a term we all know, fruit of the poisonous tree, if you will, but anything that grows out of that, and particularly if it is the basis for these violations, because every one of these violations is based upon a supposed conversation between Mr. Chukwurah and his clients, and supposed advice that he gave his clients. Let me move on real quickly to the elements.
Can I ask one more question? I know you need to move on, but
Yes, sir, Mr. Cruz.
what's your view of the impact of exceptions to the attorney-client privilege? Crime fraud exception, breach of duty by a lawyer to or a client, those are exceptions to the privilege.
Yeah, and I think that if the client complains and waives the privilege, or if the client sues in a malpractice case, that's waived. But I do not think that if the client never complains, and if neither client, the mother or Eric Hernandez, never complains, then I don't think it fits into an exception if for a complaint based upon that comes from a third party, if you will. I think you've got to have client input into creating an exception.
Okay, so in your view, in order for an exception to the attorney-client privilege to apply, there has to be some input one way or the other from the client.
Exactly. From as far as the basis of some sort of complaint. That's not to say that anybody can't go down there and file a complaint. We all know that. And we all know that even on an 8.04, it doesn't take an attorney-client relationship. But I do think that in order for that to be a basis, there has to be a client input into it. One of the findings was that Chukwurah violated 1.01A by accepting or continuing employment in a legal matter which he knew or should have known that he was not competent to handle. I don't think that if you look at this record, and since this is a no evidence appeal, and we agree with Ms. Hamilton that the substantial evidence rule applies, and we agree that if there's anything beyond a scintilla of evidence, then you've got to affirm. But in this particular case, if you look at the elements of 1.01A, they just were never satisfied. The most that can be said here is that the Commission for Lawyer Discipline, if you will, called an immigration expert. Supposedly, his name was Reed Gonzalez. And another interesting factor about this was they also attempted to call Mr. Donald Cassidy, the person who had filed the complaint, who was an immigration lawyer with the government. He said, "I can't testify. I've been told by the immigration department not to come down here and give any evidence. I can't give you any opinion." Even though he'd already written a report in rebuttal to the grievance, he declined to testify. So I don't think we can look to his testimony for any basis, because he didn't testify the record, and his oral testimony of when he said that is the best evidence, and not his report that was supposedly, which constituted a response to Mr. Chukwurah's response to grievance, a reply, if you will. Entering that into evidence is nothing more than hearsay if the best evidence is the testimony, and the guy comes before you and says, "Well, I've been told by the Immigration Service I can't testify." So in order to try to get around that, the commission calls then a fellow named Reed Gonzalez, who is in the evidentiary panel hearing, who is a supposed immigration expert, and he says, "Well, I don't agree with any of this advice that Mr. Chukwurah gave to his clients. None of that works under the immigration code. None of that works under our immigration laws." There was a dispute about that. Of course, Mr. Chukwurah said, "Yes, it does. There are loopholes in the immigration code, the immigration laws." I don't profess to be an immigration expert, but at least there's a dispute about that. But here's the point. The point is, in analyzing a 1.01A violation for lack of competency, you have to show that either Chukwurah possessed the legal knowledge, skill, or training reasonably necessary for the representation of Hernandez, Mr. Gonzalez, or any other evidence, or any other witness ever testified about that, so there's no evidence on that. Or you have to show that Chukwurah did not have the ability to acquire the training reasonably necessary for the representation of Hernandez. There's no evidence on that from Mr. Gonzalez or anybody else in the record. And so, aside and apart from somebody that would have to opine as to the subjective feeling of Mr. Chukwurah as to whether or not he knew or should have known that he was incompetent, which almost is an impossibility. You can't bring an immigration expert in to say about that, because how is he going to know what's in the person's subjective feelings? So we don't think there's any evidence on that point aside and apart from the attorney-client privilege problem. The second rule violation that was found was a 201 violation. A lawyer shall exercise independent professional judgment while representing a client and shall render candid advice while representing a client. If you look at comment number 4 to Rule 2.01, it will tell you that a lawyer's advice at best often consists of recommending a course of action in the face of conflicting recommendations by experts. So even if he had a conflicting, even if his advice was conflicted by Mr. Gonzalez, Reed Gonzalez's position that, hey, you're all wet, there's no loopholes in the immigration laws at work, then that's not a violation of the 2.01. Interestingly enough, if you look at the finding of fact on 2.01, the finding of fact says that the respondent failed to give the client straightforward advice expressing lawyer's honest assessment of the case. Well, that's the comment to 201. That's comment number 1. So what they've done is found a violation of the comment and not a violation of the rule. Obviously, we all know that comments are guidelines, but they aren't quasi-statutory like the rules are. So the finding of fact that supposedly supports 2.01 is a violation of the comment, aside and apart from the fact that there's no evidence that he violated 2.01. Let's go to the third violation that they supposedly found him to have violated, and that's 3.01. A lawyer shall not bring or defend a proceeding or assert or controvert an issue unless the lawyer reasonably believes that there is a basis for doing so that is not frivolous. Well, the only thing that Mr. Chukwurah filed was a bond request with the immigration court. Then he filed a motion for redetermination of the denial of the bond request, and he filed a brief in support of that. And if you look at what the finding of fact was that supposedly supported the sanction, you will find that the finding of fact says respondent attempted to bring a proceeding before the immigration court that respondent knew was frivolous and without merit, as Hernandez could not be eligible for the relief prayed for. Well, I'm sorry, but 3.01 doesn't have, we don't sanction a person for 3.01 for attempting to do something. So the finding of fact doesn't even support the rule. The rule says a lawyer shall not, and the finding of fact says he's being penalized and found to have violated 3.01 for attempting to do something.
Mr. Parris, I'm sorry, I think your lights aren't working. Your first 17 minutes are up, but in light of the questions, why don't you take about 2 more minutes and then reserve what other time you have for
Pretty fast, thank you, Your Honor. Comment number 3 to 3.01 quickly says, the matter is not frivolous if a lawyer believes such may not prevail, even if he believes it may not prevail, and it's just a long shot. And that's exactly what it was. It was a long shot. But even Reed Gonzalez testified that if it was a long shot, and in fact, the lawyer reasonably believed that he is filing, what he is filing will help the client, does not violate the bar rule. The commission's own expert said that in the transcript. Finally, 8.04A3, and let me get through this real fast because this is the old catch-all rule we all know about. Conduct involving dishonesty, fraud, deceit, or misrepresentation. If you look at the few cases that have interpreted that rule, they say that conduct's got to be deceitful, it's got to lack honesty, integrity, and probity. Giving advice to your client as to the possibilities of remedies sets a dangerous standard if you're going to hold that to be deceitful, lack honesty, integrity, and probity. And so, in fact, Rule 8.04A3 is not even supported by a finding of fact in the judgment of suspension. In fact, the only thing that it can come from is giving misleading advice to the client, again, we get back into the attorney-client privilege, and again, we get back into a situation where there's no evidence of that by simply talking about possible remedies. Thank you, Your Honors, and I'm sorry it took so long.
Thank you. Ms. Hamilton?
May it please the board, good morning. This case is about a lawyer who took on the case of an immigration client who was in a dire situation, and it was a situation where the lawyer could not have reasonably believed that he was competent to represent that client. The board should affirm the judgment of partially probated suspension that was entered by the panel because there's a reasonable basis in the record for each and every finding of misconduct, and Mr. Chukwurah's complaints about the admission of the evidence have no merit, and they also were not preserved. The first violation found by the panel involves Rule 1.01a, which prohibits a lawyer from accepting or continuing employment in a matter when the lawyer should know that matter is beyond the lawyer's competence. It's clear from the use of the phrase should know in this rule that it's based on an objective standard. And it's clear from the comments in the rule that the manner in which a lawyer handles a client's case can provide very good evidence of whether the lawyer was actually competent to handle the case. In this case, the commission proved that in 1 month of representation, Mr. Chukwurah made multiple serious mistakes in the representation of his client. Some examples are that he believed the client was entitled to be released on bond because the client wasn't convicted of a violent crime and he wasn't a threat to national security or a flight risk. But the record establishes that exactly the opposite was true. He was not entitled to be released on bond. The order entered by the immigration court actually noted that the court had no jurisdiction in that matter. The motion for the bond hearing itself relied on case law that was more than 20 years old, even though immigration law has changed dramatically in the ensuing 20 years. Mr. Chukwurah also failed to recognize, and this was a critical issue, that deferred adjudication is considered a conviction for the purposes of his client's deportation proceedes. He also advised the client that he could avoid. Pardon me?
I'm sorry to interrupt you, but is it your opinion that no lawyer could have helped this young man?
No, that's not the opinion. I think that's beyond the scope of this particular case. In these circumstances, it's a bunch.
That because, as I recall in your brief, there was some statement that this poor 18-year-old kid had gone to the lawyer and was now being deported from the only home he had ever known to some foreign country. And I was just wondering if the result would have been different had he consulted competent counsel.
Possibly the result would have been different. I can't really speak to that issue. It wasn't one of the issues in the brief, but I think that the focus, there was no focus in this case on the fact that Mr. Chukwurah's conduct, I'm sorry, Mr. Chukwurah's discipline needed to be enhanced because the client was deported. The results weren't really what was focused on. It was the fact that the potential results were so grave for the client, and it was so clear that Mr. Chukwurah did not know very much about the issues that were relevant. That was the focus of the case. The commission didn't take the position that but for what happened here, this client wouldn't have been deported. I think that would have been a difficult argument to make. It's not clear from the record whether or not that was the case, but it is very clear that Mr. Chukwurah didn't understand the issues that were relevant to his making a decision about whether or not he could help the client. And if it were true that there really wasn't much that any immigration lawyer could do for the client, there was a duty for Mr. Chukwurah to explain that to the client before he even took on the representation. Or maybe once he took on the representation, but he realized that once he learned all the facts and maybe even did some research, he realized there wasn't anything he could do there. He had a duty to let the client know that so the client could proceed accordingly. As it ended up, the client was in immigration court by himself, a teenager, 18 or 19 years old, in an immigration court by himself facing the judge and just saying to the judge, I can't do anything here, just go ahead and deport me.
So you're saying in essence that harm to the client has nothing to do with this consideration?
In this particular case, that's right. We are not here saying that but for what happened here, this client wouldn't have been deported. He may very well have been deported, but that's not the focal point of this case.
All right, thank you.
Ms. Hamilton, you may be getting to this, but can you respond to Mr. Park's argument as to whether or not there would have been competent evidence, assuming the attorney-client privilege was not waived to the point that the panel or we cannot consider any evidence that came from Mr. Chukwurah that constitutes a waiver of the attorney-client privilege?
I think there are really two issues that are relevant to that question, and I want to make sure that I make both of these points. And the first is, just from kind of a logical standpoint, that argument doesn't make a lot of sense in this context. We don't have a case where the nature of the violations shows that Mr. Chukwurah's supposed inability to present some information to the panel harmed him. We're talking about his competence, which is demonstrated clearly in the record. He hasn't articulated some information that he wasn't able to share with the panel that might have enabled him to defend himself better. And if necessary, and he felt like there was some evidence that was so sensitive for his client that he wanted to make very sure that it wasn't disclosed unnecessarily, he could have taken steps to do that, to make sure that that part of the record was protected. There's nothing like that here. He just sort of makes this blanket assertion that, sorry, this can't go forward because of the attorney-client privilege. If attorneys could do that, my office couldn't do its job. The commission would be hampered from disciplining lawyers because lawyers could so easily claim attorney-client privilege. In addition to that, my second point is that if you look at the disciplinary rules, in particular Rule 1.05 and Rule 1.05C talks about this very issue. It talks about confidential information. It's all information that a lawyer comes into a lawyer's possession in the course of representing a client, including privileged information. And there are some exceptions, very specific exceptions to the non-disclosure requirement. And one of those is if the attorney needs to respond in a disciplinary case, then he can do so. Still, of course, the attorney should try to honor the attorney-client privilege as much as possible and not disclose more than necessary, but an attorney can do that. Like I said, if there's something particularly sensitive, and this doesn't look like one of those cases, but if there is, he could have done that. But with the issues we're talking about, incompetence, not being frank with the court, those just aren't those kinds of issues.
Ms. Hamilton, in the context of this case, where do you believe the line is crossed between malpractice and incompetence?
I don't know exactly where the line was crossed in this case, but I know that the facts in this case are so egregious that there is no question about Mr. Chukwurah's lack of competence to handle this particular case. The record even shows that Mr. Cassidy, who was the chief for the Immigrations and Customs Enforcement Office, in their law office, he felt so compelled by what had happened here to make this complaint, and it was something he had never done before. He'd never filed a grievance again, and that's clear from the record. Both Mr. Cassidy's letter, which was admitted without objection at any point, there was no objection to that letter, it goes into detail about all of the issues related to Mr. Chukwurah's incompetence. And in addition, the expert's testimony and the expert's report also, that both went into great detail about the problems here. So based on this record, it's abundantly clear that Mr. Chukwurah should have known he didn't have the knowledge, skills, and experience to represent this client in this situation.
Do you see it? I'm talking about the difference between this, like a malpractice and incompetence. Do you see that as the degree of, or the egregiousness of the error, or the number of the error, or is there some sort of temporal relationship? They have to all occur in a short amount of time, and
I think all of those issues could be factors. I think it's one of those things that you have to look at on a case-by-case basis, but yes, it could be that there are so many basic errors made, as in this case, that that incompetence is proven. It could be that the types of errors that are made are so egregious, there's incompetence. Now, the rule makes it clear that we're talking about an objective, reasonable lawyer standard. So we have to determine what would a reasonable lawyer, how would a reasonable lawyer have acted under the circumstances? And this record makes it clear, based on Mr. Cassidy's letter, based on the testimony from the expert and the expert's report, that a reasonable lawyer would have known better than to do the things that Mr. Chukwurah did.
And if there is no damage to the client, does that have any impact on this rule?
Damage is not the issue. Damage could be a factor in determining how aggravated the misconduct is. You know, usually the damage to the client is more an issue in the sanctions phase of a case than it is at the misconduct phase. But when we're talking about, for example, Rule 2.01, and that a lawyer has a responsibility to, to speak frankly with the client, and for example, in this case, to say to the client, I don't know of anything that I can do for you. I don't know a lot about these issues. You should probably hire somebody who's more experienced with this particular kind of situation. With that kind of a situation, the potential consequences to the client are relevant, because it was so important for Mr. Chukwurah to honor his obligation because of the potential consequences to the client, and candidly say to the client, I can't do anything for you. Maybe somebody with more experience can.
Is that what you think is the violation of 201? Because 201 kind of puzzled me in here. I'm not sure if you look at it, counselor, advisor, and I don't know that I've seen a 201 raised. I just don't recall that. So
I think 201 was a tricky one for me too. It's not one that I've seen a lot either, but it fits this record. If you read the text of the rule itself and you read the comments and the kinds of obligations that are involved with Rule 2.01, the kinds of obligations that are imposed by the rule, I think that Mr. Chukwurah's failure to give his client straightforward advice about his immigration matter, and the fact that he couldn't help him and he needed somebody more experienced because this was such a serious case, I think it is the kind of conduct that it was reasonable for
isn't
the
there kind of a conflict, though, between arguing that he's so incompetent to violate the first one? If he's that incompetent, then where does his honest assessment? I mean, if he was competent and had an honest assessment that was reasonable, he has a duty to give it, but then you're arguing he's incompetent. So isn't there kind of a tension between those two? Or at least that's how I read it. It seems like a strange rule to bring.
And I think that it's not one of the issues that was raised by the parties, but I think that if that were the sole basis for the finding that he violated Rule 2.01, then maybe Mr. Parris could have questioned that. If we were trying to say solely that, okay, he was incompetent, he didn't understand these issues, didn't know anything about them, and we were then trying to say at the same time that it was dishonest for him not to give his client, tell him what these issues were about when he didn't know it, that might present a conflict. But we have the additional issue here, or the separate issue of his not being frank with the client about his own ability to do anything for the client. He not only did he not tell the client, I can't do anything for you, but he told the client, I can do all these things for you. You have all these potential avenues, when he couldn't have reasonably believed that. And so that's what I hope answers that question about any potential conflict between the 8.04A3, the 1.01A finding and the 2.01 finding.
I don't want to belabor this too much, but what is the advice he rendered which was not candid, which is what the rule actually says? It doesn't say straightforward or honest or competent or anything like that. It says you're supposed to render candid advice, which I've always thought of as, don't just tell them what they want to hear, be candid. But But that's my question. What exactly is the advice he rendered which was not candid?
Well, once Mr. Chukwurah met with his client and he understood the actual facts of the case, he should have just candidly informed the client that, he didn't have the knowledge or the skill or the training to assist somebody in this situation.
But if he's that incompetent, he might not know that. He may be given the advice he thinks is candidly right. He doesn't know better.
Especially since we don't know what the client would have said if the client had testified.
And wouldn't that get you to a subjective standard at that point, that as opposed to the objective standard you've been telling us about?
Yes, that would get you to a subjective standard. And, in this current immigration client, this current immigration climate with this extremely rigorous standards, it just wasn't reasonable for him to walk in and present himself as somebody who was competent under these circumstances and who could assist the client in ways that were clearly not available. What the record seems to indicate is he, instead of being upfront with his client and frank with his client about those issues, he instead moved forward with the representation, presumably in order to have this client to collect this fee. And that's the kind of thing that should be prohibited by Rule 2.01.
You have about, we'll give you a couple more minutes because of all the questions, but right now you have about 4 minutes. So,
Okay.
just let me know,
Okay.
since your light's not working.
So we've talked a little bit about Rule 1.01a. It's clear that from the record that Mr. Chukwurah just lacked the basic skills to understand and handle this case. That's clear from the record, and the evidence just speaks very loudly about that issue. We've talked also about Rule 2.01 and his duty to render candid advice to his client, including telling his client, I can't help you, or I don't have the skills to even know whether there's anything that can be done for you. You should talk to somebody with more experience in this area. If nothing else, he should have known he didn't have the experience with somebody in this situation to move forward with that representation. The last two rules, 8.04A3 and 3.01, are related. 8.04A3 prohibits conduct involving dishonesty, fraud, deceit, or misrepresentation, and 3.01 prohibits frivolous filings. And the comment 3 to that rule makes it clear that a filing or contention is frivolous if it contains knowingly false statements of fact. Those violations are proven by the transcript from the immigration court, where it's clear that Mr. Chukwurah was not frank with the court. His client even said to the judge on the record he was not comfortable continuing with Mr. Chukwurah, in part because Mr. Chukwurah had encouraged him to lie to the court. It's clear from Mr. Chukwurah's answer and from his pleadings that yes, he in fact knew that the client was not married, but he represented the client as somebody who was legitimately married. There's some discussion in the brief about some kind of a common law marriage might have existed. So there might have been some basis for him to take that position, but that's not the position he took with the court. He represented to the court that the client, as if this client did have some kind of a legitimate marriage, when that clearly was not the case, and he was aware of that. He misrepresented that in 2 motions filed with the court and in the bond worksheet. And in addition, we have this very act of moving for the client's release on bond was frivolous in and of itself because there was no reasonable basis for filing that motion. So in conclusion, an analysis of this record makes it clear that the panel's findings of misconduct are well supported by the testimony of the commission's witnesses and the exhibits that were entered, only one of which drew any objection. All of the other exhibits were admitted without objection. And this record, which provides serious proof of egregious misconduct, supports the judgment that has been entered, and that judgment should be affirmed in all respects. Thank you.
Ms.
Ask a
Hamilton,
question.
one question I just want to clarify.
Way fast enough?
Right. I just want to make sure I understand your 201 response. And is it your position that that rule was violated because Mr. Chukwurah did not tell his client that he, Mr. Chukwurah, was not competent to handle the matter? Is that the basis for it?
That is the basis for it, yes. He should have been frank about that. I think we even get to a subjective standard on that. This record just doesn't support any conclusion other than that Mr. Chukwurah had to know that he wasn't competent to represent a client in these circumstances, and he did so anyway.
Okay, well, let me just stop you there. Under the incompetence one, you say it's an objective standard, correct?
Yes.
But on 201, do you agree with me that we now need to get into a subjective standard that he actually knew?
It seems to be less objective than some of the other rules that we're talking about, 1.01A, for example, the competence rule. In this case, I think we easily get beyond a pure objective standard. I don't think that we can go so far as to say that the commission's got to put on proof of somebody's state of mind other than putting on proof of the circumstances that existed like they did here, like we see in this record.
Would it be your position that there would be at least some evidence that he subjectively knew that he was incompetent?
Yes, I think that the facts speak loud and clear. You cannot reasonably reach another conclusion. And again, this is not an issue that was raised by the parties. This would be unassigned error. I haven't explored it in that detail, but yes, I think that we get there.
If for some reason, and let's say that it's Mr. Kittner is unreasonable and persuades the rest of us that one of these charges, 101, 201, 301, perhaps, fails for some reason, what is your view on what happens then? Let's say we affirm on 3 out of 4 or 2 out of 4. What happens then?
The board has in the past and does have the authority to reverse part of the judgment, but still impose a sanction and then enter a new judgment. The board can do that. It's clear under the appellate rules and under your rules as well. The board's done that in several cases in the last few years. So you could do that, or the board could choose to remand the case for a new sanctions hearing. And in this case, if one of the findings, for example, there's been a lot of discussion about 2.01. If you reverse that finding, for example, we're still talking about the same underlying facts. You haven't found that any of the findings of fact aren't supported by the record. You will be finding that there's some legal issue, again, not raised by the parties, but some legal issue that you think is troubling here. But we're talking about the same conduct. What you would be concluding, I guess, is that the commission applied too many rules to the same conduct. One of them didn't fit, but we're still talking about the same conduct. Really, the same or a very similar sanction is warranted. And there would be no reason to go back to the panel with that issue because no further development of the record would be needed.
In the past, it's as I recall, at least one instance, the commission and the party agreed that if the board were to reverse, that we wouldn't need to send it back to the panel because the parties would agree on a sanction. Is the sanction that's imposed here one that the commission would ultimately agree to, even if reversed on some ground or other?
Potentially. The same sanction that we have?
Yes.
Well, sure. Yes, the commission would agree to that. I don't know if
I was thinking yes was the right answer, but
Mr. Chukwurah might not, and I'm not sure what his feeling would be about that.
we'll ask. Thank you.
All right, thank you.
Anybody else have any questions? Thank you, Ms. Hamilton. Mr. Paris?
Just briefly, and I know I only have a couple of minutes, so, would the result have been any different, Ms. Jones, if Mr. Gonzalez, for example, Reed Gonzalez, the expert for the commission, had represented Mr. Hernandez? I doubt it. I don't think any lawyer could have obtained a ruling from the immigration judge granting a bond, for example, if the judge didn't want to grant a bond. We see that every day in criminal cases. in connection with,
Does that mean that Mr. Gonzalez would have been candid with Mr. Hernandez and told him, I can't do anything?
no, what it means is he would have said, he would have said exactly what he said in his testimony. It's a long shot, but here are some possible remedies. Let's pursue these possible remedies if you want. But you know, it's a long shot, and that's what he says that he told him and the mother in his testimony, and we do that every day. I don't go in to guaranteeing, nor does any lawyer go into guaranteeing a result for anybody. We don't. Whatever these facts that come to us, we get saddled with, and if they're not good facts, we try to do the best we can with them. But giving the client the possibility of a long shot and saying, if you want to pursue this, fine, but it may not work, is not incompetence. And if you go, I think that the disciplinary prosecutor has to prove up their case by proving the elements of the rules. And in this particular competence matter, 1.01A, he would have had to prove that Chukwurah either didn't possess the knowledge, skill, or training reasonably necessary at the time of the acceptance of the representation, or because that's how competence is defined in terminology, or he would have had to prove that Chukwurah couldn't gone out and studied the immigration code and come by that competence or come by that knowledge.
Well,
that was not proved up.
You'd agree, wouldn't you, that, and I think you just said, we can't, as lawyers, make up the facts.
That's right. And I don't think he made up any facts.
Would you agree that it would be a violation of 804 if he knew that Hernandez was not married but represented that he was? Would that be a violation?
If he knew it, but where's the proof that he knew it? The mother said he's been living with this woman in a common law relationship.
He's 18 years old.
And he said, well, you know, possibly if that's a common law marriage, and we might be able to go to the justice of the peace and get a certificate showing a common law marriage. That's what the suggestion was. It wasn't like, oh, I know that you're not married, but we're going to say you're married. That is not in the transcript. There's nothing that constitutes a misrepresentation in the transcript. There's nothing deceitful, if you will, under 8.04A3.
But what about the representations that were made during the immigration hearing from the client, from the 18-year-old?
The client, what I understood those to be was the client said, he wants me to say I'm married and I'm not married. Something to that effect.
Right, but isn't that enough to show that an effort to mislead or some sort of artifice?
I don't think so. If you are looking at it from a subjective point of view of Chukwurah saying, if you've been living together, holding each other out as being married and believing between yourself as you're married, then you're married. When he comes up there, the client comes up there in front of the immigration judge and says he wants me to say I'm married and I'm not married, and he admits he's not married. That's when Chukwurah withdraws, is fired, is terminated. He no longer represents him after that.
I mean,
so I don't think that's evidence that he lied to anybody.
Hernandez says he basically wanted me to say stuff that wasn't true. He wanted me basically to lie. That's the quote from the hearing. Isn't that the scintilla of evidence? Isn't that enough to say that an 8.04 violation is present? Given everything else? I mean, that to me is very troubling. I mean, I don't know how you get around that.
Well, I don't think that is the way Chukwurah said the information that he gave came down. He said, I understood from what I knew, based upon what the mother had told me, that these people had been living together. And if they've been living together in a common law relationship, then it could be a common law marriage. Now, we don't know whether the client was saying to the immigration judge, I'm not ceremoniously married or not. So I think there's a lot of wiggle room in there. And I don't think that you can,
Here's the trouble, if there's a lot of wiggle room in there, and this is on appeal, what's the standard?
well, I don't think there's, the standard is set
If there's
forth
some
by-
evidence
Yeah,
from
but
which we can
if it's-
conclude that the panel got it right, don't we have to affirm?
if there's more than a scintilla of evidence, but in City of Keller, in Keller versus, City of Keller versus Wilson, the Supreme Court says a no evidence review cannot disregard contrary evidence showing witnesses were not qualified to give an opinion. And to the same extent, I think you can't take into consideration something somebody said in a hearing when you have a live witness saying this is exactly what was said. So here, that's what we have from the standpoint of levels of admissibility or levels of evidence.
And same
Neither
question,
one of the-
same
neither one of
question
these-
I asked Ms. Hamilton earlier. If for some reason we don't buy all of the 01s, the 101, 201, 301, but, you know, we buy 3 out of 4, 1 out of 4, and affirm on that basis, reverse on that basis, we send it back.
Here's my suggestion, Mr. Jones, that this be remanded to the evidentiary panel for a reassessment of the sanction, given the fact that the sanction isn't severed for each one of the individual counts.
And that's what my question was, is would
And I don't
your
think that
client
you-
agree to the same sanction, or are we gonna have to send it back if that's the determination it's
Well,
made?
we're not gonna agree to the 3 years active, 2 years probated, not even with some prior discipline being used for enhancement purposes. And I think that since there is no assessment of discipline on each one of the counts, as opposed to a gross discipline for all of the accounts, you can't say which one weighed more heavily in the eyes of the panel members, the evidentiary panel members, and which one did not. And so therefore it has to be remanded. That would be my answer. The only other thing I have, and I know I'm out of time, I've been out of town for a while, but I know Mr. Cruz asked about the malpractice situation. This is not a situation where we determine what a reasonable prudent lawyer would have done under the same or similar circumstances. That's negligence, that's malpractice. The standard of care, if you will. He wasn't even charged with neglect under 101B, which is above the standard of care and constitutes conscious indifference that we all know about. So the reasonable prudent standard that Ms. Hamilton has argued to you is not in any of these rules. There's no reasonable prudent standard involving whether or not you're competent. There's no reasonable prudent standard that embellishes upon whether or not you've given candid advice or whether or not you file something from a frivolous standpoint, outlandish legal theory, if you will. That is aside and apart and doesn't play a part in the disciplinary rules, in my opinion, Mr. Cruz. That's all I have. Thank you.
Anybody else have any questions? Thank you very much. We'll take this under advisement and issue our ruling later. Before we